Hello, everyone. It's 1 p.m. and I would like to start the public hearing, but I believe some commissioners were going to join, so I would also like to wait maybe 3 or 4 minutes. I hope that's okay with everyone.
Sure.
No problem, Judith.
Okay, I see that Commissioner Hall has joined. So I would like to start the public hearing at this time. This is a public hearing in a rulemaking proceeding entitled "In the matter of a commission rulemaking regarding NMPRC Rule 17.7.3 NMAC Integrated Resource Plans and Procurement Procedures." Case number 21-00128 UT. It's March 15th, 2022 at approximately 1:03 p.m. And the notice of proposed rulemaking was issued on November 3rd, 2021, and it set forth a procedural schedule for comments and publication and for this public hearing today. I have a sign-up sheet that was provided to me, which I will make part of the transcript of this public hearing. And it lists names of people who will be making comments, and then names of people who may or may not speak. And we have with us today Commissioner Cynthia Hall, and we also have her assistant, Colin Gillespie. We have with us Robert London, who's the assistant of Commissioner Fishman, and Commissioner Fishman may join us. In addition, we have with us today Arthur O'Donnell, who is an NMPRC staff member fellow from Department of Energy, who has assisted us with preparing this rule and the case. And I don't have any other introductory comments, and I would just defer to Commissioner Hall as to whether she has any comments she would like to make as an introduction. Okay.
I just wanted to say thank you to everybody who's here and has gone through all the effort to read the rule and make comments and care enough to come and participate. We've put a lot of effort into it, but we know you guys really do too, because your clients have to live with it. So it's very important to your clients, and I appreciate that, and I appreciate the quality of the arguments you make. So thank you very much.
Okay, thank you. And with that, I'll go through the list of people who signed up to actually make comments and definitely wanted to speak. And the order is the order that was presented on my sheet, which I believe Isaac prepared, and it probably was in terms of date of request. So with that, Jim Desjardins of REIA, would you like to make the comment?
Yes, I'm sorry. Thank you very much. I had a little struggle there with my Zoom apparatus. And commissioners and Commissioner Hall, thank you very much for the opportunity to provide comments on 21-00128-UT Integrated Resource Plans and Procurement Practices. My name is Jim Desjardins, and I'm the Executive Director of the Renewable Energy Industry Association of New Mexico. We're known by our acronym of REIA. We have a diverse membership of about 45 members, small mom and pop companies and large multinational companies, including solar integrators, developers, manufacturers, distributors, and a local community college. And basically, we want to start by just acknowledging that the electric power grid that we have currently in place is an awesome machine, but it needs updating. And we believe that this updating needs to include distributed energy resources. These resources would be behind the meter solar on commercial and residential buildings, but also front of the meter, known as community solar. There's a lot of new technologies out there like smart inverters and energy storage that can help distributed energy resources play a vital role in the modern grid. And part of what distributed energy resources can do is to be able to dispatch energy at key times when the grid is in need of energy. But we need to basically design the updates to the grid to reflect this. And part of this design is to include looking at distribution lines, specifically in terms of the amount of information provided to developers and their hosting capacity. I would like to acknowledge that at this moment, there are 18 distribution lines on the P&M system that are closed to any size of solar. So this is something that's very important for our members. And we commend the Commission for looking and directing electrical utilities to provide distributed energy resources in their integrated resource planning process. Thank you very much for the opportunity.
Thank you, Mr. Desjardins. The next person I have is Ms. Joan Drake from Interwest Energy Alliance.
Good afternoon, all. I hope you can all hear me okay. Please let me know if for some reason I fade out. I think you all know Interwest. We've been commenting on an IRP and procurement rule for several years now. I've lost track of the number of iterations of comments that we have provided. This is one of many. So I don't want to take everyone's time in reviewing all of the comments that we've already made. I think they are of record. I did want to touch on a few of the issues that I think folks have raised in comments that that we wanted to emphasize the importance of some of these points. And I know we have reply comments as well coming up in the next month or so. So I won't belabor these points, but we're certainly open to questions and discussion. First, I know that there has been some concern about whether this proposed rule somehow invades the management prerogative of utilities. And clearly that's not something that Interwest wants to do. And we don't think the rule necessarily does that or has to do that. If there is a concern that somehow it steps too far or that it could step too far, we feel that that's not a good reason to eliminate the entire rule, that there are ways to protect against that. In particular, I think we need to recall and keep in mind the main objectives of this rule. And if you look at section 17.7.3.6 of the proposed rule, which is the objective section, that's what we're really trying to get here to, not to take over the utilities business, but to meet these objectives and to make sure that we all of us are meeting these objectives, including transparency, stakeholder input, fair and robust competition, and finding the most cost-effective portfolio. Interwest has been emphasizing those objectives now for years, and we think that's what the focus should be, especially with the review process that's established in these rules. If we need to set guardrails to ensure that the commission is not trying to make decisions for the utility, I think we can do that without throwing away the entire rule, because these objectives are important and worthwhile. Secondly, I think folks have also raised that there should be some exceptions to this proposed rule, such as for emergencies and small procurements and procurements for individual customers, and there might be others. I think that those are reasonable exclusions. Again, I don't see that as a reason to throw out the entire proposed rule. I think we can put in some guardrails and exceptions that will address those kinds of circumstances. Thirdly, I think there's been an objection to the linkage between IRP on the one hand and procurement on the other. And the notion has been raised that not all procurements are linked to an IRP, so these rules should be separated somehow. We don't necessarily agree with that. It seems to us that procurements have naturally and typically followed an IRP. That's kind of what an IRP is designed to set up, is looking at what the procurements in the next 4, 5, 10 years should be. So there's a natural linkage there that we think should not be ignored. We understand that there could be some procurements that are not necessarily an outcome of an IRP, but again, that's not a reason to throw out the rule. It's a reason to maybe put in some additional guardrails or whatever, or provisions that accommodate those additional procurements, but it's not a reason to not do the rulemaking. Turning to some more substantive issues, I think there's been some objection to what Interwest proposed in terms of portfolio modeling. And I know we don't have much time today. We'll get into more of this in our reply comments, but we think it's important to consider portfolio modeling because the outcome of an IRP is a portfolio. It's supposed to be the most cost-effective portfolio. So the notion that we shouldn't be looking at portfolios is inherently wrong, I think. And the outcome of resource replacement inquiries have been portfolios of projects that were individual bids, but they were grouped together into a portfolio. So it makes sense to look at portfolios. I think also from a practical standpoint, portfolio modeling can provide more insight into what bid combinations make sense and could meet the identified need and could share costs. For example, if there's a transmission constraint, that if the costs of solving that would be too much if it was lumped into any one bid, if you grouped bids together and shared those costs among bids, that portfolio bids may become the most cost effective. We're not even looking at that now. So our view is that that ought to be something that ought to be looked at. Lastly, and I'm sorry if I've gone over my time, Judy, but lastly, we understand there's been some objection to considering transmission as a part of an IRP. And again, we think transmission is a key critical piece here. Transmission facilities are resources as well. I think an IRP deals with not just generation, but how do we get the generation to market? For example, one of the primary reasons that I understand that PNM recently acquired the Western Spirit transmission line was to access renewable energy from Eastern New Mexico. Arguably greater transmission availability with neighboring utilities and markets could help provide pathways for additional energy during summer peaks and winter emergencies. Transmission is a key critical piece of how to get resource generation to people, to market. It should not be ignored. It should be part of the process. Thank you for letting me go on for probably more than my time. I appreciate it, and we will be providing reply comments as well. I will just note my associate Lisa Tormain Hickey, who is a counsel for Interwest as well and has experience in many other states in addition to New Mexico, is also on our Zoom. She's very knowledgeable about how these things have worked in other states. So if folks have questions, she is a great resource on that. Judy, thank you for letting me go on for so long. Thanks.
No, we don't have all that many people who actually want to provide comments, so it's fine. The next person I have on the list is Nicholas Stoffel from the New Mexico Large Customer Group.
Thank you, Judy, and good afternoon to Commissioner Hall and Commission staff. So I'm Nick Stoffel with Holland & Hart, counsel for the New Mexico Large Customer Group. And for everyone's awareness, the NMLCG is a group of industrial customers who take service from SPS in New Mexico. We've submitted initial and reply comments so far, and as indicated in those comments, we largely support the direction the Commission is proposing to go with the IRP rules. We believe the transition from really an informational filing to more of a meaningful approval of the resource needed action item is an appropriate step. And as explained in our reply comments, we certainly believe the Commission has the authority to adopt the rules it's proposed. I won't go further in reciting what we've already put in the record in written comments, but I do want to just comment on the recommendations from some parties that there be additional workshops. We certainly appreciate the intent that that suggestion is offered, and in the ordinary course, we think it would be helpful, but in this instance where there is such disagreement about whether the Commission has the authority to implement the rules it's proposed, absent, I think, a clear change of direction in the kind of rules the Commission wants to adopt, we really question how meaningful or productive those workshops would be. If there's ongoing disputes about the Commission's authority to approve the resource need and approve an action plan, and to link that to the resource acquisition process as proposed, it seems like conducting workshops to further explore those ideas would not be very productive. So I wanted to offer that. It was not in our initial reply comments, but did want to help move the conversation forward today and appreciate the opportunity to provide these comments and certainly answer any questions that you have.
Thank you very much. I assume that Austin Jensen will not be making comments. Is that correct, Nick?
Yep, that's correct. Thank you.
Next, I have Joseph Yar for Onward Energy.
Thank you, Judith. Thank you, Commissioner. It's a pleasure to be here today. And it's also an honor that the Commission has allowed Onward to participate in these rulemakings, which are so vitally important to the outlook and the future of New Mexico. First and foremost, Onward stands with the Commission on what we consider a long overdue rulemaking on these specific issues, namely the IRP and the RFP process. Onward would like to state for the record or for this proceeding that this rulemaking creates a sense of transparency and openness to a process that has historically been kept in a secret. Onward fully supports implementation of the proposed rule and believes it will be a tremendous benefit to all the parties in interest and ensure that a deliberative, fair, and efficient process is in place for consideration for future IRPs and RFPs. Lastly, Onward stands by its filed comments in this case and firmly believes that this rule is a great opportunity to grant the stakeholders and the Commission with access to vital information. We'd also like to point out that this process exists in other jurisdictions already, so it's not revolutionary. I don't want to waste everybody's time. I echo Mrs. Drake's comments and Mr. Stoffel's comments. They are well on point. And with that, I'll close. Thank you very much.
Thank you. Next, I have two representatives from El Paso Electric Company, Ron Moss and Nancy Burns. Who would like to speak on behalf of EPE?
Judy, I'll speak on behalf of EPE. Can you hear me?
Yes.
Okay. Thank you. My name is Ron Moss, and I represent El Paso Electric Company. EPE appreciates the opportunity to present comments at this public hearing on the Commission's proposed IRP rule. EPE also appreciates all the hard work that the commissioners and the staff and other stakeholders have devoted to the proposed IRP rule. EPE supports the Commission's proposal to repeal and promulgate a new IRP rule. And like Ms. Drake said, we don't have any interest in having this entire rule thrown out. If this were just a rule about the IRP process, the resource planning process, we would have few concerns about the rule. We have provided some suggested improvements to parts of the resource planning provisions, but in general, we think it's a fundamentally sound rule insofar as resource planning is concerned. El Paso's concerns are directed primarily to the resource acquisition parts of the rule, which are sections 17.7.3.12 and 17.7.3.14. Now, as you heard earlier, EPE and some other utilities have argued that the Commission does not have statutory authority to promulgate a rule governing resource acquisitions. And we stand by those comments here. But the Commission has good lawyers like Ms. Amer, and it will reach its own conclusions about its own statutory authority on this issue. So I won't address the statutory authority issue further in these public oral comments. I want to focus instead on some more practical concerns that EPE has about the resource acquisition portions of this rule. From EPE's perspective, there's still much work to be done with respect to the resource acquisition provisions before this rule is ready to be adopted by the commission and applied by the stakeholders. And I guess here's one place where we would differ from the New Mexico Large Customer Group, because we do think workshops would be helpful, and I'll return to that in just a moment. But let me just give you some examples of the problem. These are just examples of problems we see. It's by no means exhaustive. If we look at section 12, it appears to us that subsections E and G are in conflict. This is the one that governs the RFP process and the bidding. Subsection E allows a utility to propose a method to protect the confidentiality of the bidder's information. But subsection G requires the utility to share all bid information with the utility division staff and the interveners. It's not clear to us how a bidder's information can be protected if the utility has to share all of the bid information that with every intervener or every party that intervenes in the commission proceeding. EP is also concerned that bidders will be reluctant to submit bids if they know that all information is going to be turned over to the interveners in a commission proceeding, including possibly other bidders. And that's just one example of a concern we have about section 12. We also have some concerns about section 14. For example, section 14 provides that the commission can rely on the independent monitor's opinion and report as evidence in a utility's prudence proceeding. But subsection J of that rule says that the independent monitor is not subject to discovery or cross-examination. Allowing the commission to rely on the opinion of the independent monitor, but not allow any party to conduct discovery or cross-examine the independent monitor would raise some real due process issues that could put these commission decisions at risk on appeal. And again, we have many more concerns, but more generally, nothing in either section 12 or 14 explains how these resource acquisition provisions are intended to interact with other commission rules governing resource acquisitions, such as the Renewable Energy Rule and the Long-Term Purchase Power Agreement. There's also nothing substantive in the proposed rule addressing the effect that the proposed resource acquisition will have on multi-jurisdictional utilities, such as EPE and SPS. Now, these are not insurmountable problems. It's certainly possible to address these and other defects in the resource acquisition provision, but it's going to take time and it's going to take input from the stakeholders. And for that reason, EPE proposes that the commission delete subsections or sections 12 and 14 from this rule, delink them as the New Mexico Affordable Reliable Energy Alliance has proposed. We agree with that, and we believe staff agrees with that. I'm not trying to put words in anyone's mouth, but we believe that we should delink those provisions from the IRP rule. That'll eliminate most of the controversy surrounding the IRP rule, and it may avoid an appeal of the rule. Now, if the commission believes that it's important to have a resource acquisition rule, and if the commission believes it has statutory authority to adopt such a rule, there's nothing to prevent the commission from issuing a new notice of proposed rulemaking that focuses primarily on the resource acquisition process. That would allow the commission to address these resource acquisition issues that stakeholders have identified in the current rule, and it will allow the commission to consider the interaction between the resource acquisition rule and the other rules that govern resource acquisitions, as I mentioned a moment ago, the Renewable Energy Rule and the Purchase Power Rule. And then finally, regardless of whether the commission keeps sections 12 and 14 or deletes some, we would urge the commission to schedule some additional workshops from the rulemaking in this docket and give the stakeholders more time to work out their differences. We do believe that there are places where we can still reach some consensus, particularly on the resource planning side of this. Scheduling a few extra workshops may delay this process a bit, but a short delay in approving it is preferable to promulgating a rule that may be appealed and that may be very difficult to implement. once again, thank you for the opportunity to provide comments on the proposed rule.
Thank you very much. Next on the list, we have, I was looking at the rule and going back to my comment. P&M, Leslie Padilla and Stephen Schwebke. And who would like to speak on behalf of P&M?
Ms. Amer, this is Leslie Padilla on behalf of P&M. I'm on the phone. You can't hear me, correct?
Yes, I can hear you.
Okay, good. But as you said, Mr. Schwebke, I'm corporate counsel with P&M. Mr. Schwebke is from our regulatory. He's the regulatory case manager. He's joined as well. Thank you very much for allowing P&M to comment. And I wanted to particularly thank Commissioner Hall for her remarks, appreciating the work of all of the participants in both this formal rulemaking and the several informal proceedings that led to this rule. And P&M has actively participated in all of those proceedings. We appreciate that the proposed rule issued with the NOPR did reflect some of the concerns that P&M had raised earlier. We do still have significant and considerable number of concerns about the proposed rule. We've submitted both initial and response comments, and as we did, I just checked, we submitted a 14-page long spreadsheet of comments about individual sections of the rule. I think that indicates just kind of the level of concern about the rule because it is so detailed. One of the largest concerns, and I'll just go to what Mr. Moss proposed, is with the procurement regulations being made part of this IRP rule. We would support removing sections 12 and 14 as EPE suggested. It doesn't even necessarily make sense that procurement regulations would be in a rule that is called integrated resource planning, at least to P&M. And there have been some very widely divergent comments so far submitted in this rulemaking, to the point where P&M is concerned that the record so far does not really provide sufficient basis to support the proposed rule. I wanted to focus my comments here today on something that we raised in our response comments, and that's two possible options in terms of directions the Commission might go at this point. First, we suggested perhaps just pairing the proposed rule back to back to the IRP as a planning process. The Commission previously found, of course, that the IRP was just that, a planning tool only under the Efficient Use of Energy Act. However, if the Commission, does want to turn the IRP back into something that actually has more weight in terms of evidentiary weight for utility resource acquisition proceedings, we would propose, and this goes to the point that Mr. Moss raised on behalf of EPE, that there really be some considerable consideration of the changes that would need to be made both to the proposed rule and to corollary rules of the Commission concerning purchase power agreements, Rule 551, Rule 572 on renewable energy, the energy efficiency rule, because if the IRP, the action plan, is intended to determine over the course of whatever the planning period is, or the next 2 or 3 years, then need for additional prudence reviews would ideally be unnecessary. And to Mr. Yar's point that other states have actually accomplished this, we agree, and P&M has tried to take every opportunity to, inform the commission and put material in the record about useful guidance from other states. We've particularly looked at Colorado and Nevada recently, but those states are examples where they do have a holistic and comprehensive integrated resource planning process that is tied to procurement or tied to resource acquisitions, and that means the approval of an IRP's action plan does mean the commission is awarding a finding of prudence for acquisitions that are related to that IRP. So in our reply comments, PNM does plan to make the commission aware of specific changes that we think are necessary to these other rules. I think I mentioned the energy efficiency rule, the PPA rule, the renewable energy rule, and the CCN regulatory provisions that would need to, we believe, go hand in hand with this approach to an IRP that the commission appears to want to take. And because those additional rulemaking, those additional changes would need to be made to the other rules, we do agree that stepping back from this and going back to some workshops to talk specifically about how to make sure this all works in sync are necessary. Again, thank you so much for allowing us to have this opportunity to speak, and we look forward to filing reply comments for you. Thank you.
Thank you very much. Next on the list, I have Adam Harper from OE Solar.
Thank you so much. I don't have any comment. I will leave my comment to Jim Desjardins at RIA.
Thank you. Next, I would call on staff. I believe Brad Foreman is present.
Thank you. Staff has filed its comments, both initial comments and response comments, and we are currently reviewing whether to file any additional comments, which I believe are due 1 week from today. So we don't have anything that we wish to add at this hearing.
Thank you. At this point, there's no one else signed up to provide comments. Are any of the other participants who are present now, would they like to provide comments? Any other members that from staff or the commission? Well, hearing none, I would ask if anyone who has previously made comments, would anyone like to provide a reply comment?
Judy?
Yes, yes, Joan, go ahead.
Yeah, hi, this is Joan Drake with Interwest. I just wanted to emphasize a couple of points with respect to workshops. If you recall, we've already had
a series of workshops on the independent monitor portion of the rule. So, and those essentially, we took a lot of time, and Nancy Burns, bless her heart, did a lot of work on leading that effort with us. Thank you, Nancy, for the time that you put into that. And but the outcome, I mean, we did probably work out a few things, but the ultimate outcome was that we all had to kind of agree not to agree. So I don't recall who it was who made the point that if there's just some fundamental disagreements here, I think the commission is just going to have to take those into account and make its decision based on the input it's got. If folks really do think that there are some narrow issues or sections that we could fine tune the process, and not just not agree on whether to include those whole sections or not, but if there's some fine tuning of a process that we think could result from getting together, I think that's fine. We would have no objections to that and would want to take part in that, as long as it's narrowly focused and not just an excuse to delay and delay and delay. We've been delaying this rule now for literally years, and it's time to come to a conclusion on this. And we think there's a good enough record, or there will be, for the commission to make its choice here. Secondly, I think what PNM and Leslie were talking about what was the prudence presumption or rebuttable presumption issue. And I think and Leslie, please correct me if I'm wrong about this, but I think PNM's point was that if the process it is not a really meaningful process, or if the commission wants it to be a very meaningful process, then in that case, there should be a meaningful outcome. There should be a meaningful substantive result, which would be a presumption of prudence, perhaps rebuttable in a later case. I think Interwest is in support of that, because we'd like to see the IRP and procurement processes become more meaningful, and the commission review of that be meaningful. And one of the reasons is that we've all seen recently that if you wait to do those reviews in a CCN or a PPA case, it can be too late. If the resources are needed and needed now or needed very shortly, it's almost as if the commission has a gun to its head at that point in time. And it almost becomes de facto that, you've got to do this or else. So it seems to us that the IRP and resource procurement process is the right time to do that kind of review. And again, I go back to the objectives of the rule in section 6. And the commission's review ought to be focused on ensuring that the process has met those objectives. If it's met those objectives, great, then they deserve a meaningful outcome. If the process has not met those objectives, then the utility deserves to be informed of how it has not met those objectives, and to be told, you got to do something to meet those objectives. And here are some ideas. Here are some stakeholder and commission thoughts about how to do that and why this is important. That's, to us, that's the right time to do that analysis, when you have time to think about it and to actually make adjustments. And lastly, and again, thanks for letting me take time here. But lastly, Interwest completely understands the comment regarding confidentiality of bids. It's our members who are, many of whom are bidding on projects throughout the state. They have concerns as well about their bid information being kept confidential from other members and from others who want to compete with them. Our members all compete with each other. What they want is a fair, level, transparent playing field. That's what they want. So they can all compete and they can provide New Mexico with the most cost-effective portfolio of resources for whatever its needs are. But I think those concerns are valid, and I think those can be worked out. Again, I don't think it's a reason to throw out the entire rule, but those protections are important, and we would support making sure that the confidentiality protections are robust. Thank you for letting me go on again, Judy.
Oh, no, you're welcome. Would Leslie or someone from PNM like to reply, or would anyone like to reply regarding workshops, confidentiality, or presumptions?
Judy, this is Leslie Padilla. I'd like to reply to Joan. And yes, Joan correctly understood my comments, and they may have been in a bit of shorthand, so apologize. But I was referring to any presumption of prudence that might attach to a commission's approval of whether it's the statement of need or action plan. I'll just back up because that's still confusing in the rule that there's both a statement of need and an action plan. But I think it's the action plan that would possibly trigger a prudence finding, although I would point out in the current draft of the rule that prudence determination is really unclear. There's not a direct statement that a commission approval of an action plan, what that means in terms of prudence findings for the approved resources. So, and then the next step though would be to make sure that, yes, if it's, I think Joan's word is meaningful, if the IRP is meaningful, that subsequent regulatory proceedings that are currently allowed for in our rules, that some of those then would really ought to be eliminated if in fact the approval of a utility statement of need is a presumption, perhaps a rebuttable presumption of prudence. Then do you need the PPA rule at all? Because what you would be doing through this robust, probably lengthier IRP. I know the Commission's proposed rule thinks the IRP would take less time. Actually, in other states, I think Nevada and Colorado are both good examples. The process is actually expanded because of what you have to accomplish in that type of an IRP proceeding. So the effect of a, as Joan mentioned, a meaningful IRP, the effect of that on other Commission resource acquisition proceedings really does need to take place right now as we try to improve the IRP process in New Mexico. Thank you.
Thank you. Would anyone else like to reply regarding the presumption?
Can I speak for a moment, Nick Stoffel?
Yes.
And I just want to echo Leslie's support for looking at the Colorado ERP rules as a model. And I'll note that that process has resulted in very robust bidding and a very competitive process. Those rules specifically address the treatment of confidential information, establish that presumption of prudence for actions consistent with the approved portfolio, and integrates resource planning and the RFP process as has been contemplated. So it is an area where I think if the Commission wants to look for an example of how those things have been brought together in a very successful way, Colorado is a good example of that. And so just wanted to throw that out there. I know we put that in our response comments, but since it has come up a few times as kind of a gold standard to look at, would echo that the NMLCG does support that approach.
Thank you very much. Anyone else? Lisa?
Yes, thank you. I would just echo, because it's always a positive thing when we can agree on some things, that Colorado does provide a good example. And I'll just note one portion of that process is that after a very thorough analysis of what the utility should acquire and how it should model that so that the results of the bids can be fully explored, Colorado does allow the utilities to choose which bids to select, but it gives some guidance about whether they have complied with the initial order approving the resource plan. So there is some look back and assurance that it was done fairly and in accordance with those original rules, but then they do also give the utility the choice. certainly to establish a reliable plan and to really determine how to comply with the commission's orders related to and to implement the policies established by the commission.
Thank you very much. Is there anyone else who would like to make an additional reply?
Judy, one piece I forgot to mention that I thought of when Lisa was just talking to is that the Colorado process does not obviate the need for certificate of public convenience and necessity for those investments. And so there is that parallel issue going on here, but experience shows it certainly does make those less contentious when they're saying essentially this is just part of the portfolio that was approved through that litigated resource planning process. So now the PPA rule may be something else to consider separately, but that does have the example of it doesn't obviate the need for those filings, but you do carry the presumption that that action consistent with the approved action plan is necessary. And then it's a look at the specifics and whether things have changed. So there are some issues that can come up, but it, again, I think tracks what the discussion has brought out today in a way that can address some of these problems.
Thank you very much.
Judy?
Yes.
This is Joan again. I wanted to note agreement with Nick Stoffel on that. I didn't mean to imply that we would not think that a CCN or PPA proceeding is unnecessary. I think it is necessary, but as Nick noted, it could make those much less contentious. Thank you.
I see Ron Moss.
Yeah,
Ron?
Judy, I just wanted to add one other thing. The fact that we're talking about I'm not an expert on the Colorado rule, but the fact that we're talking about the Colorado rule here as being perhaps a model, and the fact that we're talking about what other proceedings this might affect, like the CCN or so forth, I think just reinforces the fact that we need to step back and take another look, particularly at the resource acquisition part of this. That's and to what Joan was saying earlier in her reply comments, I agree with her. There's no point in having workshops for the sake of having workshops, and certainly not just to say we disagree with this. But there's some real issues like the confidentiality. How do we deal with those in a way that's truly protects the information? And we need to figure that out before we get the rule adopted. So if the commission were to strip out sections 12 and 14 and put them in a new rule, as I suggested earlier, I think this IRP rule can move pretty fast. But I think that if those stay in the rule, that we have a lot more thinking to do about how all this fits together. Thank you. I appreciate the time for additional comment.
Oh yeah, thank you very much.
Judy?
Yes, Commissioner Hall.
Yeah, I would just like to ask Mr. Moss, I read the comments, but it hasn't been recently. And so I don't know if has anybody proposed, I was listening when you were making those comments about, the need for some confidentiality during the process. We really worked on that a lot, but we'd certainly welcome suggested language. If you have any suggested language, I don't know if you've proposed any already, but if you had pertaining to confidentiality and maybe even some language on your issue related to cross-examination of the independent evaluator, I thought you made some interesting points. And in particular, I'd like to understand maybe more specifically, well, I don't know, it might be too complex. If you could propose any language on the multi-jurisdictional issue, that's pretty tricky. But if you have language to propose, that'd be really helpful. And I'm also making that comment to you, Leslie and Nancy. We've had a long workshop process and the interconnection rule. I'm suppose some of you have been involved in that. I know Nancy had been there. I don't, and Leslie, I think you were. I don't know about you, Mr. Ron, but so I appreciate when people can say, well, we don't really think we're going to get there, but we can agree to disagree or whatever. Leave it up to the commission at that point. So I understand what people are saying when they don't want to go through more workshops. And I think that doesn't prevent us from still having a few further conversations on some of these points, because I really do want this to be a rule that works for everybody. And, we've put this out as what we imagine could work. But, and I know you've said things in your comments, but to the extent you can elaborate with more detail or suggested language, that would really be helpful. We'd like to look at.
Yes.
And I understand the issue about, I hear what you're saying about creating a different procurement rule, but we had started out with this concept in mind because it just seems to make sense to us. So I don't know that we won't end up taking it apart, I believe. But I mean, of course, it depends on what the other commissioners say at the final, analysis. But I appreciate you talking about looking at Colorado. We'll study it some more. We certainly have looked at Colorado for various aspects, and we do want this to be a process that's not going to take forever, because when bids are made, we don't want them to get stale, for example. And when you look at our objectives, as Joan says, there's not all the time in the world. You can see a whole year go by with things happening in a proceeding that are just a result of different viewpoints. So what was I going to say? I lost my train of thought. Those are some underpinnings of the rule that we think are really vital right now, which is to get things done promptly and as efficiently as possible. And that's a big underlying concept in combining planning with procurement. And procurement follows from planning. So to us, it was a kind of a fundamental idea that made sense. So I doubt if we'll change any of that. But given that, to the extent there's language you can propose that would help you achieve, address your concerns as much as possible, please suggest it. Because, we can sit around and have more workshops, but still it comes down to us sitting there sitting as a group saying, how do we put this on paper? It really helps if you guys can suggest things.
I understand, Commissioner. I appreciate that. We did identify these issues in our opening comments, but we may not have done a good enough job of providing some suggested alternative language. So we will, in reply comments, we will plan to maybe do a more robust set of comments in terms of the concerns that we have, and maybe some language that would fix that. And so we'll plan to do that, and I appreciate your giving us that guidance.
Great, thanks. I appreciate all the effort you guys have made. I really do.
Thank you, Commissioner. And unless somebody notifies me by a chat or some sort of waving of the hand, I believe that would conclude the public hearing.
Okay.
And thank you, everyone, for your written comments. And I see Joseph Yar, please.
No, I was just waving goodbye.
Oh, okay. Goodbye, everyone.
Bye. Thank you very much.
Bye-bye.
Bye.
Thanks all.
Yeah. The